Welcome to Sakshi TV Special Immigration Show. I'm your host, Shivani Raj. For today's show, we have Ms. Prashanthi Reddy. Please note that Sakshi TV now has 4 immigration shows every week. On Tuesdays with Mr. Srinivas Kaviti, on Wednesdays with Prashanthi Reddy in English, on Thursdays with Chand Parvat Neni, and on Fridays with Banu Nindra. Please tune in to ask your questions. If you are an immigration attorney and would like to join our special shows, please email us at usalesakshi.com or call us at 866-725-7441. Before we begin the show, please note that the information provided on this show is not legal advice and for general informational purposes only. Sakshi TV or its agents will not be responsible for the use of information. If you need any specific legal advice, you can contact the attorney directly. Ms. Prashanthi Reddy needs no introduction, but if you need consultation, you can definitely log on to their firm, reddyesq.com. So without any further delay, let's welcome Ms. Prashanthi Reddy on our show. Hello, Ms. Prashanthi Reddy. How are you? Welcome back.
I'm good, Shivani. How are you?
I'm doing great. Thank you so much for asking. Thank you again for tuning in. So, Ms. Prashanthi Reddy Garu, today we will, we are discussing a little more. This is actually like a continuation of the previous episode that we had. But before we get onto the topic, can we cover, are there any recent immigration updates that the viewers might want to know?
Yes. So one update that I wanted to cover was with reference to CSPA, which is the Child Citizenship Protection Act, which pretty much it's for children who have aged out. So just to give you some background, when someone files a 485, which is a green card petition, it could be employment-based, it could be family-based. The child, in order to get the green card along with the parents, has to be under 21. And the requirement is that the child should file the 485 before the child turns 21. So once the child files the 485, then the child's age freezes, which means that if they turn 21 after that, if it takes like 2 or 3 years for the 485 to get approved, then the child will still get the green card. So what had happened is, what was happening is, under the employment-based cases especially, if you look at the visa bulletin every month, there are 2 tables. One is a dates for filing table and the other is a final action date table. And then the USCIS tells us every month which table we should use. So usually if they predict that there will be a requirement or there will be space available for them to accept new filings in the future, they might say that, okay, go ahead and use dates for filing chart. So according to the dates for filing chart, the green card number is not actually available, but they're allowing you to file in advance in anticipation that it will become available within a year. So what the previous law was that if someone filed a 485 under the dates for filing chart, since the green card number was not technically available at that time, and you're filing based on a future availability, the age of the child would not freeze. And so, for example, let me give you an example. In 2020, when a lot of 485s, hundreds, thousands of 485s were filed, in October of 2020, because during the pandemic, since the consulates were closed, the EB2 and EB3 visa numbers suddenly became available for 2010 and 2011. So a lot of cases were filed under the dates for filing chart. So unfortunately, but those cases, the children could not adjust because those cases, they took a long time to process them. And not only that, since the visa number is not actually available, if you file under the dates for filing chart, your 485 can be pending for years even, until the date becomes current based on the final action date table. So in the meantime, if you file based on dates for filing chart, your child could easily turn 21 and be over 21, and then that 485 for that child would have been wasted. You've paid the money, you filed the entire petition, but it was wasted and could not be used. So now they have said that whether you file under the dates for filing chart or you file under the final action date chart, the age of the child will be frozen at the time that you file the 485. So for those people who couldn't take that benefit earlier, you can also file a motion to reopen now to reopen that 485 and get the benefit of this law. So that's a huge relief for a lot of IT professionals and other people also who have been waiting for years and years under the employment-based category 2 and 3 and have seen that their children have aged out and haven't been able to get the benefit of the green card along with them. So that was the one update that I wanted to give.
Yes.
And this happened, the revised guidance was issued on February 14, 2023, sometime back, but we never actually talked about it. And recently, the American Immigration ALA, the American Immigration Lawyers Association, also provided some practice pointers on what to do and how to process these cases. So if anyone has a child who's aging out, please contact your immigration attorney, or you can contact me and we can see if we can file a motion to reopen for you.
Yes. Ms. Reddy, in the last episode, we kind of discussed everything about the H1B petitions, but we didn't really start much about the H1B cap. So my first question for you was, how will one qualify for the H1B cap, their benefits? So let's say one is filing for the H1B cap. So can they qualify and, get their benefits from it?
So basically, in order to qualify for basically the cap gap benefit. So cap gap benefit is when you're filing a change of status from an F1 to a H1, as per the cap gap rule, the person on F1 continues to remain in status, even though their OPT might have expired or maybe they finished their school. So instead of having to enroll in a different school or file for an OPT expansion, the way the USCIS did it is they created this cap gap benefit, whereby they would artificially remain in the same status, whatever status they were at the time of filing the H1, until October 1st, until the time that the H1, October 1st is the start date for the H1. So until the H1 starts, they'll continue to remain in whatever F1 status they were at the time of filing. Now, when does this cap gap benefit apply, or when does someone qualify for the cap gap benefit? That is attached to you whenever you file the H1B petition, not upon registration, but upon actually filing the H1B petition. And in order to qualify for it, you would have to file, this would continue until October 1st, unless the H1 was withdrawn or revoked or denied. Then it could cease before October 1st as well, or September 30th as well. Otherwise, it's extended, the cap gap benefit is extended until September 30th, 2023, and the benefit applies to you as of the date that your H1B reaches the USCIS office.
Yes. So let's say, Ms. Reddy, that somebody is on their F1 visa and their EAD has been expired, before the 10th of the January 2023. Can they really stay back in the USA? Do they have any rights of staying back? And if not, or if yes, can you please explain in detail about the situation?
Sure. An F1 whose OPT AD is valid at the time of filing the H1B cap petition, and if the OPT EAD will expire before October 1, that person will remain in valid status and may continue to work until September 30th. So the day before October 1st, because October 1st, presumably your H1 is starting. Unless your petition is rejected, your H1 petition is rejected or revoked or withdrawn by your employer. So whichever happens first, September 30th or withdrawal or revocation, etc. Now you have to remember, to obtain this cap benefit, not only should you file your H1B petition, but you also must select change of status in the I-129 Part 2, Question 4B of the form. So you cannot file for consular processing. If you indicate that you're filing for consular processing, then the cap gap benefit will not apply for you. So it's only for H1B petitions. And also you have to show that you are presently on an F1 status. So question 4B is relating to, on the I-129 form, is relating to what your status is. And you have to indicate that your status is an F1. So if you don't fill out the form properly, or if you're not asking for change of status, then you will not be able to remain in the country and continue to work on OPT EAD until September 30th.
Yes.
So if your OPT EAD has expired as of the date of filing the H1B, but say you're in the grace period of your OPT EAD, then you will remain in that status until September 30th. So whatever your status was as of the date of filing the H1B petition, artificially your status will be frozen and you will remain in that status until September 30th. So that's something to keep in mind. So you don't have to file for an OPT again and get it extended, etc. But of course, after September 30th, if your H1 doesn't get approved, and sometimes that might happen, then your cap benefit, even though you don't have to leave the country, but you will not have the cap benefit, which means that you will not be able to continue working or studying, etc.
Yes. So the earlier question, I kind of mixed up with the dates. I said it was January because it's different here in India. But again,
Right.
but again, so when exactly can one apply for the cap subject H1B petitions, Ms. Prashanthi Reddy? And how different will the process be now when they want to apply for the cap subjects H1B petitions?
Yeah, so you have 90 days to file, and the 90-day filing period will be listed on your registration selection notice. So when you file a H1B registration, if your case is selected under the lottery, you will get a registration selection notice, which will say that you have until so-and-so day to file. So in general, for this first batch of selections, since it's 90 days, you have until June 30th to file your registration, to file your H1B petition, I mean. So, but please remember that don't file in the last moment, especially if you're using US Postal Services, you're not using a courier service, and you send out to a PO box. Remember, USCIS picks up the mail from their PO box at a certain time that day. And if they have already picked up the mail from the PO box for that day, and your petition arrives on the same day, but after they have picked it up, they will consider it for the next day. And so you would not have filed on time. So just be aware of these things. And simply filing is not sufficient. They have to actually receive the petition before June 30th, 2023. A lot of things can happen. So please be aware and file your petition well in advance.
Yes. So, Ms. Reddy, let's talk a little bit about the premium processing service. So, can one request for it, and also how much is like the money difference? How much will this cost compared to the normal processing that happens?
So, premium processing costs 2,500 extra in addition to what you're paying for your H1B, and you have to submit a copy of the I-907 premium processing form. And so this year, yes, every year it's different because sometimes USCIS will stop premium processing for cap cases, but as of now, they have not said they're going to stop it. So we have to presume that they're allowing premium processing for H1B cap petitions. But I suggest that you, before you file your petition, look for the updated news and make sure that cap service is still available for, premium processing is still available for cap cases. And then you file your H1, make sure you send your 2,500 check, write your check correctly, date it correctly, and don't forget to send the I-907 form. Yes.
So, Ms. Reddy, should separate filings for fee checkings, separate filing fee checks, must they be submitted during, when you're actually applying for it?
Yeah, so earlier we would submit one check. So just to give you some background, when you're filing an I-129 petition, there are different types of fees involved for the same petition. There is 460, which is the basic fee. Then there's a ACWIA fee, which is the training fee, which is $750 to $1,500, depending on the size of your company, the number of employees that you have. Then there is a $500 fee. So there are three different fees that go into a I-129 petition, and depending on your case, you'll have to pay a certain amount of fee. So in the past, these 3 different fees, we would club it together, put it in one check, and write one check to the US Department of Homeland Security. But now they've given us updated instructions, and they are saying that they want a separate check for each type of fee. So the basic fee of 460 separate check, ACWIA fee separate check, etc. Premium processing fee separate check. And of course, if you have a different form that you're submitting, like an I-539 form for a H4, if you're submitting a H4 along with a H1 for the dependents, then you have to, obviously, always it's been a separate check for that H4 form. So yes, separate fee for each, separate check for each fee, and the entire name of the USCIS has to be spelled out, US Department of Homeland Security. So just make sure you put separate checks, because they're following a system, a different system whereby they're inputting the checks into different systems apparently. So they want separate checks.
Yes. So where exactly is this petition filed, Ms. Reddy?
The petition usually is filed based on the worksite, but for CAP cases, you have to send the petition by looking at the address given in the registration selection notice. As I said, when you register, they send you a registration selection notice, which you should then attach to your H1B petition, and that registration selection notice will give you the exact filing address. Because they are not going based on geographic area, they're going based on their convenience. They're trying to be equitable with reference to, where the case goes out. So that they want to make sure they're equitable with reference to processing time, so that it doesn't make a difference. Processing time doesn't make a difference. No matter where you send it, they're distributing it equally. So send it to the address in the selection notice.
So will the USCIS select additional electronic registrations from the reserve this year?
So yeah, this question is basically you're asking if we'll have another lottery, and just to let you know, we don't know whether they will or not. But in prior years, there were several selections, but for last year, for example, they selected 127,600 cases, and there was only one selection. And they said that they have received enough cases, and they have selected enough cases to take into account those people who won't file also. So a lot of people register, but they don't actually file the H1B petition, in which case then that H1B number gets wasted. So that's why we were hoping that there would have been more selections last year, or at least another lottery, but that didn't happen. Let's hope it happens this year, because it's kind of hard for USCIS to predict how many cases will get selected and then have an initial selection based on a prediction. It's better that they select only the number that they need, and then if the cases don't get filed by June, then they can have another registration, so that the cases, it's more accurate that way. So whatever cases were not filed, they'll have the exact number. They can put that back into the pool, and then they can have another lottery. So I don't know why they didn't do it that way last year.
So Ms. Prashanthi Reddy, let's talk a little about the FBINS now. So, before we get onto this topic completely, can you just give a basic introduction about what exactly the FBINS is to the viewers watching the show?
Right. So very quickly before that, if you don't mind, I'll cover another question.
Yeah, sure.
Because this is asked by, again, a lot of people.
Yes.
And the question is, what if the H1B petition is erroneously rejected and the 90-day filing window has passed? Can we then file the request to reconsider from USCIS and again file it even after the 90 days? So basically the response to that is, you have 90 days to file your petition. You have until June 30th. So you file the last day, and because of USCIS's fault, they reject the application and send it back to you. If it is their fault, I guess you have a good case to prove it to them that you did everything correctly and resend it, even after the 90 days, but whether they'll accept it or not, that's a different story. In the past, when they made a mistake with reference to the start date, they did accept cases even after the 90 days, but a lot had to be done and said before they would do that. And it's not on a case-by-case basis. It was basically a decision that they made based on multiple cases. So if it's just unique to your case and something happens, most probably you may be out of luck, even if it's USCIS's fault or your fault. So I think the moral of the story is please file in advance so that you don't have to face this situation. Coming to FTNS visits, basically what is an FTNS visit? FTNS is an agency that is used by USCIS to conduct fraud investigations on the H1B petitions that you're filing. And you're paying that additional ACWIA fee so that you're funding the FTNS visits with that additional fee that you pay. So it's mandated by law that FTNS, this organization, which they provide contractual services to USCIS, and they perform audits to see whether you're compliant with your H1s or not, and then they prepare a compliance report and send it to USCIS. That's their job.
Okay.
So typically an immigration officer's job is to verify all the information, including all the supporting documents that you submit with your H1B petition, verify that the organization actually exists, review all public records of your case and the information that you've provided, conduct site visits. That means they'll come in person and usually unannounced, and they might come either to the work site, they might come to your office, or they might come to the home if the work location is the home. Then if they come for such visits, they might take photographs of the work location. Their job is also to review documents, to interview people. So to interview the employees or to interview the HR at your company or to interview the owner so that they can confirm the beneficiary's work location, the physical workspace. They interview you also to make sure, number of hours that you're working, the salary that you're getting, duties, etc. So this is the task of the immigration officer. That's what they're supposed to be doing.
Yes.
Also, they usually ask for certain documents. So just before that, let's look into what can be done before the site visit. How can you prepare yourself for a site visit, an FTNS site visit? Because an FTNS site visit will happen to everyone. It's inevitable because these are random. They're sometimes random audits. Sometimes it could be triggered by something. Maybe somebody complains to USCIS, but it's often that they are random. So you should expect that you will get a site visit at some point, and if you are prepared for it and if you have a protocol or a process in place, then there'll be much less anxiety with reference to a site visit. So I think before a site visit, it's important to develop a staff protocol for the site visit. Appoint a point of contact so that only that person will talk to the officer. Perform an internal audit of all your cases to check if the job duties, the work location, the salary, these are all consistent with the I-129 petition that you filed. Make sure your public access files, you're supposed to maintain public access files for every H1, and the FTNS officer can look into those public access files, and they're supposed to be available on demand. So make sure you're always up to date with your public access files and they're all located in your office. Also, it might be prudent to run a mock site visit. So you can, the mock site visit will ensure that, people won't panic when somebody comes to the office, and everybody will know exactly what their role is. So maybe one person can play the role of a FTNS officer, the other person can be the person receiving them. And the employer can prepare questions so that the HR person is well versed on how to answer these questions and how to deal with the situation without panicking or without giving wrong information. So if you have a protocol in place which says, for example, that you will ask the officer to, you will not answer a question that you don't know. Instead, you're going to ask the officer to write down the question and say that you will answer it via email.
Yes.
Or you can always say that I need a week, I need a postponement, I'm going to hire an attorney to respond to this audit. So please give us a week to respond. So you can have a process in place so that even if there's something that you don't know, you're able to, respond to that easily.
That's where I was going, Ms. Reddy. Sorry
Yeah.
for bothering.
Go
You
ahead,
can continue, but the question is pretty similar. So that was my question. So if they come, can one decline and be like, no, you guys can come after later, or, I would want my attorney to come speak for it. Is that a good option that, the employees can consider? And what is your view on this?
So a lot of some attorneys who are aggressive might say, oh, you don't need to talk to them. FDNS site visit is voluntary. You do not have to participate in it. Only give them information that you want to give, blah, blah, blah. But you have to remember, even though an FDNS site visit is voluntary, if you do not submit the information that they're looking for, they might issue a compliance report which is negative to you, and they'll send it to USCIS. And then the USCIS, based on that, might send you an intent to revoke on your already approved H1. So I think within reasonable limits, you can push back, but it has to be reasonable. So for example, to answer your question, if the contact person, the owner, whoever the person is that has to talk to the FDNS officer, if that person is not there, then obviously we don't want someone else who's not qualified to answer the questions. So the receptionist should be trained, prepped to say that, look, the person is not there. We can either call the person and you can come back at a later time, or, give me a card and I will ask the concerned person to contact you, because I'm not qualified to answer your questions. I don't have the requisite knowledge or, answers to the questions. So that is reasonable.
Yes.
Because the contact person has to be there. You don't necessarily have to say, we want an attorney present. But you can always say that, the contact person is not there. Now, even if the contact person is there, you can welcome the officer in, answer questions to the extent that you know. Remember, please don't answer just off the top of your head. You can ask them to see the office. You can show them where a particular person works. And if there are any other questions that they ask that you don't know immediately the answer, you can just say, look, I will look it up and I will send you an email. Because I don't remember right now. I don't have that information right now. Even if they ask you something basic like how many employees do you have, you may not know the answer if you have 300 plus employees, right? Or even if you have 30, because employees keep coming and going. So at that particular time on your W-2, you may not know. So you can just say, look, I have to look up my payroll records so that I can give you an accurate answer. Why don't you give me a list of all your questions and I will get back to you. So what you can do, you can definitely do that. But pushing back and saying that I will not answer any of your questions, go talk to my attorney, is not going to work in your favor.
So can you finally give some sample questions that they usually ask, when they do these site visits? What some kind of questions do they usually ask?
Yeah, sure. We have actually an FDNS audit that we did recently, and they asked the following questions. How many employees does your company have? How many of the current H1s that you have are working remotely? So they are right now pushing back on that remote work. And in this particular company had 100% of their employees working remote. What is the need to employ this person? So they want to know what is the job where they're actually working. Can you provide a list of job duties? What are their hours and days that they work? What is the current remote work address? So where is the person working from? They're asking. Sometimes employees will move from one home to the other and they don't inform their companies. So it's important, I think, to keep that always updated and to follow up with your employees to see where their address is, because sometimes an amendment might be required if they move? Does this person maintain a residence in one state, or do they have multiple homes? Does XXX work for any other business, or they only work for your company? So these are who is the point of contact at the end client location? So these are some of the questions.
Yes. We will definitely continue, Ms. Reddy. We'll discuss more about this in our next episode. But again, thank you so much for tuning in. We had such a great show. Thank you again for the viewers for tuning in. You're watching Sakshi TV with me, Shivani Raj.
Thank you, Shivani.